Dramatic turn this week with White House counsel Pat Cipollone sending a letter to House Speaker Nancy Pelosi saying that the administration will not cooperate with the probe, claiming that the House inquiry into President Trump is, quote, constitutionally invalid and violates basic due process rights and the separation of powers. Let's bring in constitutional attorney David Rivkin. He served in the White House counsel's office during the Reagan and George H.W. Bush administrations. Welcome, David. Good to see you.
Good to be with you, Paul.
So from a legal point of view, what do you make of the White House statement that this impeachment probe is constitutionally invalid and violates due process?
I may not use the words due process or constitutionally invalid, but I would say it's constitutionally very troubling. To elaborate, the framers were deeply ambivalent about impeachment power, debating whether to create it at all and who should exercise it. They understood the tremendous potential for misuse given both a British parliamentary practice but also the difficulty of cabining it. They tried to cabinet a bit, moving away from the word maladministration, which is infinitely capacious, to high crimes and misdemeanors, in addition specifically mentioning treason and bribery. Still pretty capacious. What they really expected to do is the House to unfold things with a certain decorum, follow certain procedures. Again, I would not use the word due process, perhaps, because I don't think the due process in a constitutional sense applies.
Yeah, that's the thing I want to focus on, David. I mean, it seems to me that you look at the language of the Constitution, what it says is the House has the power to impeach, okay, high crimes, misdemeanors, and so on. But it doesn't say how it goes about it. So it doesn't, they're really the same, the due process protections that we think about when we think about a normal criminal trial do not apply here. Is that correct?
That is correct, Paul. But to emphasize, the framers expected the House to unfold things in a fair fashion, and particularly expected the Senate to act in a judicial fashion. Remember, the senators take an oath and affirmation presided over by the Chief Justice. I want to emphasize one key point for your listeners. This is not a use of legislative power. The framers view impeachment as something akin to the indictment in the House and a serious trial in the Senate, and they expected things to unfold this way. If I may, what I would analogize, in essence, what the House is doing now, this is really not an impeachment process defined by historical procedures used in the three previous impeachments of a president or even British impeachments. Really doing something akin to a bill of attainder, which, as you well know, is constitutionally prescribed, specifically in Article 1, Section 9.
Explain that. Explain, what do you mean by, that's usually a bit of legislation that applies only to one individual, a bill of attainder.
Yes, it's a three parts to it. It is a bit of legislation that applies to specific individuals or groups of individuals. It is a legislation that determines the guilt of individual or imposes punishment without going through judicial process. The framers took this off the table. The Supreme Court from time to time has declared certain pieces of legislation, whether during the Cold War or following Civil War, imposing some disabilities. You may chuckle at the former Confederates' ability to practice law before federal courts as unconstitutional. So it really is a very bad thing, to put it crisply. What they're doing is very much, to me, is similar to the Constitution. They style it as an impeachment, but it really looks like a bill of attainder.
Yeah, but David, when it comes to the actual process constitutionally, they can pretty much do what they want. You can call it a bill of attainder, but the House, I just want to make clear, the House can do what it wants. The question then is the president legally on strong ground in resisting cooperation?
Well, the president is on strong ground and resisting cooperation, frankly, even if a House unfolded impeachment in a perfectly historically, procedurally proper fashion. One thing that I'm taken board from the White House's letter, standing on protecting constitutional prerogatives, even in the face of House's demands, either oversight mode or the impeachment mode is perfectly appropriate. And you can adjudicate this. Look, you're supposed to protect not just yourself, Paul, you're supposed to protect your office for the sake of preserving the separation of powers and integrity of your ability to exercise constitutional powers. So the notion that the president resisting extravagant House demands, irrespective of whatever process the House is using, is perfectly appropriate. It is not an obstruction.
Okay, it is not obstruction, but and typically these kinds of fights go to the courts, and the courts will decide whether or not the House request is adequate and the White House has to oblige. Is that how this will play out this time?
My fear, Paul, is that that's not what Nancy Pelosi has in mind. I think what she has in mind is unilaterally designating, among other things, precisely because, look, the underlying offense, the alleged high crime and misdemeanor, in my opinion, are just absolutely silly. If the president was exercising his core constitutional powers to conduct foreign policy, wanted to do something, agree or disagree with it, the fact that's politically beneficial to him, look, virtually everything you do as a sitting president is supposed to be beneficial to you, be it trade, be it arms control, be it dealing with Ukraine. So the underlying substantive case is very weak. They're going to try to level process offenses. And my fear is they're not going to go to court. They're just going to have articles of impeachment which say, whereas you did not give us everything we wanted, including every phone call with every foreign leader you've ever had, you obstructed justice. You obstructed congressional inquiry.
And they can do that, briefly, David, as a matter of constitution. They can construct an article of impeachment in that fashion and then vote on it, and then it goes to the Senate, and I guess the Senate then disposes of it as it will. But it's a weaker case if they don't if they don't actually play this out in court beforehand.
It's a very weak case, but let me underscore, it's really fundamentally not about Trump and fairness to him. My hope is the Senate would restore the separation of powers. It is about protecting the integrity of separation of powers, and the Senate is totally entitled and has to take into account not only President Trump's guilt or innocence, and I think he's innocent of high crimes and misdemeanors, but the process the House has deployed. That is essential.
Okay, thank you, David Rivkin. Very interesting.